ჩვენი საერთაშორისო პარტნიორების მხარდაჭერით, რადგან ვთქვით, რომ 20-30 აუცილებლად უნდა იყოს ის წამყვანი აჯენდა, წამყვანი დღის წესრიგი, რომელიც განსაზღვრავს სწორედ განსაკუთრებით დაჩაგული ადამიანის კარგად ყოფნას, უბრალოდ კარგად ყოფნას, რა თქმა უნდა, კონცეფციაში ყველაფერი ინგლისურობა მეტად დამსწრე ძალიან კარგად მოგესალმებით. ამიტომაც ჩვენ ვფიქრობთ, რომ ამ კუთხით ესეთი საერთაშორისო კონფერენციების მოწყობა, მათ შორის პარლამენტის როლის გაზრდა სფეროში არის ძალიან დიდი და ამიტომაც ჩვენ ის კონფერენცია, რომლის ფარგლებში ფაქტობრივად შევკრიბეთ, როგორც საკანონმდებლო, ასევე აღმასრულებელი ხელისუფლება, ასევე NGO სექტორი, ასევე მეცნიერება, რომელიც განსაკუთრებულად, ასე ვთქვათ, აღნიშნული იყო ამ კონფერენციის ფარგლებში, ჩვენ ყველა ერთად ვიჭირეთ, როგორ შეიძლება განსაკუთრებული ჩართულობით, ინკლუზიური პოლიტიკით 20-30-ის მიზნების მიღწევა. მე გავამახვილებდი ყურადღებას პარლამენტის და განსაკუთრებით ჩვენი კომიტეტის როლის კუთხით, სწორედ იურიდიული დახმარების სამსახურის მუშაობაში და მის გაძლიერებაში, მათ შორის პარლამენტის საზედამხედველო ფუნქციის გაძლიერების მიმართულებით. ჩვენ, როგორც უკვე შესავალში ვახსენეთ, ძალიან კარგი თანამშრომლობა გვაქვს იურიდიული დახმარების სამსახურთან, პარტნიორობთ მასთან და თუმცა იმავდროულად ისინი, ვთქვათ, ჩვენგანი ანგარიშვალდებული წარმომადგენლები არიან ხელისუფლებისა. ამ კუთხით განსაკუთრებით მნიშვნელოვანი არის კომიტეტის პრაქტიკა. ჩვენ ყოველწლიურად, როდესაც იურიდიული დახმარების სამსახური წარმოადგენს თავის ანგარიშს პარლამენტში, ძალიან დეტალურად განვიხილავთ ამ ანგარიშს. და ჩვენ გავცემთ რეკომენდაციებს, ბუნებრივია აღნიშნავთ ასევე იმ მიღწევათა დადებით ტენდენციას, რომელიც არის წარმოდგენილი იურიდიული სამსახურის კუთხით, ასევე გამოწვევებსაც აღნიშნავთ და ჩვენ გავცემთ რეკომენდაციებს, რომელიც უნდა ვთქვათ, რომ წლების განმავლობაში იურიდიული დახმარების სამსახური ძალიან კარგად ასრულებს ამ რეკომენდაციებს, ჩვენ შემდეგ ვისმენთ ამ რეკომენდაციების შესრულების ანგარიშს და ეს ხდება ყოველწლიურად, რაც ბუნებრივია გაზრდის კუთხით ასევე არის ძალიან მნიშვნელოვანი. როგორც ბატონმა პარლამენტის სპიკერმა ირაკლი კობახიძემ ბრძანა, ჩვენ განვახორციელეთ საკონსტიტუციო რეფორმა, რომელმაც მნიშვნელოვნად გაზარდა პარლამენტის როლი და ფუნქცია. და ასევე საზედამხედველო ფუნქცია, რომელიც როგორც საკონსტიტუციო რეფორმით არის გარანტირებული, ასევე ჩვენ მზად გვაქვს და პარლამენტში უკვე პირველი მოსმენით მივიღეთ პარლამენტის რეგლამენტის ახალი პროექტი, რომელიც ჯერ კიდევ განხილვაში არის და აქაც ძალიან დიდი როლი და თანადგომა შეასრულეს ჩვენმა საერთაშორისო პარტნიორებმა. ეს არის ძალიან დახვეწილი რეგლამენტი, რომელსაც დარწმუნებული ვარ, რომ ამ საპრეზიდენტო არჩევნების შემდეგ ჩვენ მივიღებთ. და აქაც პარლამენტის როლი, მათ შორის იურიდიული დახმარების სამსახურის კუთხით და ზედამხედველობის კუთხით ძალიან გაიზრდება და კიდევ უფრო მეტად დაიხვეწება. საპარლამენტო ზედამხედველობა ისეთ ახალგაზრდა დემოკრატიულ ქვეყანაში, როგორც საქართველო არის, ნამდვილად არ არის ადვილი. ეს აუცილებლად უნდა აღინიშნოს. ეს არის ის პროცესი, რომელიც ნაბიჯ უნდა განვავითაროთ. მოგეხსენებათ, რომ წინა წლებში ჩვენ მქონდა უფრო სხვა მოდელი და დღეს ჩვენ უკვე ვართ საპარლამენტო რესპუბლიკა, თუმცა ჩვენ ვცდილობთ, რომ ვიყოთ ძალიან განვითარებული ამ კუთხით, თუმცა ამას გარკვეული პერიოდი სჭირდება, ამას სჭირდება გარკვეული გამოცდილება და ჩვენ ვსწავლოთ მათ შორის ჩვენი საერთაშორისო პარტნიორებისგან, ევროკავშირის წევრი ქვეყნებისგან, ამერიკის შეერთებული შტატებისგან, ჩვენი დასავლელი პარტნიორებისგან, აი ამ დიდ ტრადიციებს, რომელიც მათ აქვთ საპარლამენტო ზედამხედველობის კუთხით და ვცდილობთ, რომ მაქსიმალურად კიდევ უფრო მეტი ნაბიჯები გადავდგათ დემოკრატიული მიმართულებით. ანუ ფაქტობრივად ეს თანამშრომლობა 20-30-ის მიზნების მიღწევისთვის, რომ თითეული ადამიანისთვის იყოს ხელმისაწვდომი, სამართლიანი, ასე ვთქვათ, იურიდიული დახმარება და სწრაფი იურიდიული დახმარება, ეფექტიანი იურიდიული დახმარება, ჩვენ ვფიქრობ, რომ ამას ვუწყობთ ხელს აი ამ ძალიან მჭიდრო თანამშრომლობით, რადგან ძალიან შეზღუდული გვაქვს ჩვენ
რეგლამენტით დრო, ამიტომ შევეცდები რომ ძალიან მოკლედ დავასრულო და კიდე ერთხელ აღვნიშნო ის რომ თანამშრომლობა პარლამენტისა იურიდიული დახმარების სამსახურთან უწყობს ხელს სწორედ მდგრადი განვითარების მიზნების მიღწევას და მე დარწმუნებული ვარ რომ ჩვენ მომავალში კიდევ უფრო დავხვეწავთ იმ საზედამხედველო ფუნქციასაც რომელიც გვაქვს და ასევე იმ თანამშრომლობას და ძალიან აქტიურ და მჭიდრო თანამშრომლობას რომელიც გვაქვს იურიდიული დახმარების სამსახურთან ძალიან დიდი მადლობა.
Thank you very much, Ms. Kiladze. Without attempting to summarize your very substantive remarks, I just want to underline the two important things that you have mentioned. One being that the SDGs indeed require a, if not a whole of government approach, which is a necessity, but also a whole of society approach. So, and this is, of course, very fundamental to ensuring access to justice for all. The second thing that you have mentioned was also very important, which is the oversight role that parliaments play in not only in such fundamental institutions such as legal aid services, which in case of Georgia reports to Parliament, and thus ensuring also independence of activities of legal aid services, but also you're accountable to your constituencies, to your citizens, especially the most vulnerable groups, whom you said come to your particular committee of human rights. So thank you very much. Second speaker, our next speaker is Ms. Isabelle Chan. She is the head of governance cluster of the Istanbul regional hub for Eastern Europe and Central Asia of UNDP. So my colleague, welcome. So indeed, how do institutions and organizations and oversight bodies such as parliaments measure progress in access to justice in the context of 2030 agenda? Usually in such conferences we do say that if it's not measured, then it was not implemented. So I hope you can shed some light to this question. Thank you. So you have 5 minutes.
Thank you very much, Tuya. Good morning, Excellencies, ladies and gentlemen. It's an honor, of course, for UNDP to be here and to collaborate with so many partners for this important third international conference on access to justice for access to legal aid. As previous speakers have said, the intersection between justice, human rights and development was clearly recognized in the 2030 Sustainable Development Agenda, where in 2015 193 countries agreed to an ambitious plan to transform the world over the next 15 years in the areas of critical importance for humanity and our planet. At the heart of this agenda is the vision of peaceful, inclusive, and just societies, protecting fundamental freedoms, promoting participation, non-discrimination, and access to justice for all. The 2030 Development Agenda has an ambitious goal of strengthening the social contract between states and their citizens and building societies free from fear, injustice, and violence. Despite international commitment illustrated in the Sustainable Development Goal 16, which includes the target on access to justice for all, many obstacles still remain in achieving these just, peaceful societies. As the UN resident coordinator has mentioned, global rates of pretrial detention, just to say one example, remain worryingly high and stagnant over the last decade at about 31%. This is a way of measuring, for example. And in crisis-affected context, in particular, there is large demand for legal aid services where the justice system often lacks institutional capacities and final resources to respond to the substantial amount of grievances. For UNDP, legal aid and legal assistance is central to being able to achieve the Sustainable Development Goals. We understand legal aid to be essential not only for Goal 16, but also to enable progress across the other goals. Just to name a few, to secure gender equality, protect the rights of marginalized groups, to access social services, enable fair labor. For example, legal aid can be instrumental to ensure that women are able to seek justice where denied inheritance, that indigenous peoples are able to secure the access and control over their land and natural resources, and for refugees, displaced persons and migrant workers in cities to be able to work and live without fear from prosecution by the law and other members of the host communities. UNDP works on rule of law and access to justice in about 100 countries around the world, and at least half of them we are of course supporting legal aid, service provision and legal awareness, which is also very important. I would like to give some examples here. In Bosnia-Herzegovina, starting with the region, in Bosnia-Herzegovina, UNDP with other partners. Of course, we always work in partnerships. That's why we have all the partners here. It's never one entity alone who can support. But UNDP is supporting national partners in Bosnia to establish a fully harmonized free legal aid system. In the Kyrgyz Republic, again, I would like to emphasize the partnerships. UNDP has helped to increase access to justice across the country, specifically with attention to the rights of the persons with disabilities and support to survivors of sexual and gender-based violence. This included also the partnership with pro bono defense lawyers. And then in Central African Republic, in the Democratic Republic of Congo, in Iraq, on Ukraine, all countries affected by conflict, UNDP supported access to legal aid services, including, in some cases, to support psychological and other services for survivors of sexual and gender-based violence. Quality legal aid services often aim to address root causes of exclusion and systematic biases that perpetuate discriminatory practices. UNDP sees the provision of effective legal aid as an important means through which to uphold the principle of the 2030 Agenda, which is leaving no one behind. As you all know, next year the theme of the high-level political forum on the sustainable development held in New York in July will be empowering people and ensuring inclusiveness and equality, where progress on SDG will be reviewed. Let me conclude by revisiting the recommendations from the UNDP UNODC Global Study on Legal Aid, which draw the data from 160 countries of the state of legal aid, and which was launched at the last conference in Buenos Aires. Many of these findings from the study remain relevant 2 years later and may be useful to consider also in this conference as part of the deliberations in this conference. First, enacting specific legislation on legal aid to ensure accessible, quality legal aid services, a first step to establishing effective legal aid system. Here in Georgia, we have, I think, a very good example. This requires the provision of specialized legal aid services to the most marginalized in the context of leaving no one behind in the Sustainable Development Agenda. And, for example, legal aid services for displaced persons and refugees and survivors of sexual and gender-based violence. Second, it is important for us to recognize the demand for legal aid in civil cases. Yes, this is a conference to access to legal aid in criminal justice system, but for development, for sustainable development, it is very important to discuss also the demand for legal aid in civil cases, which is often unmet in most countries. This includes access to legal aid services for civil and administrative cases, including family disputes and property matters. For many people living in poverty and facing multiple intersecting forms of discrimination, access to legal assistance to navigate the law is necessary to be able to protect their rights. And third, partnerships. Partnerships are critical in granting access to legal aid. From supporting legal awareness through university-based legal clinics, legal empowerment through community-based paralegal programs, legal aid services through civil society organizations, or pro bono support through the private sector and bar associations. With that, I'm looking forward to the further discussions in this conference. Thank you very much.
Isabel, thank you very much. I know that during the breakaway sessions and parallel sessions, we will be also discussing the data and evidence issues. I think this is very, very critical in terms of measuring progress towards SDG 16, but also in terms of how we assess the quality of legal aid services being provided around the world. So hope we can touch on this issue again during the course of the next few days. But what Isabel mentioned about social contracts fraying between societies and governments and the necessity of having these type of collaborative efforts is very, very important. Indeed, none of the SDGs can be achieved alone by one single government or by one single entity. So at the heart of upholding the fraying social contract is our networks, it's our support and collaboration to achieve the SDGs. Now, the next speaker is Annika Holterhoff. She is UN office. She is from the UN Office on Drugs and Crime, UNODC. And Crime Prevention and Criminal Justice Officer. Annika, what are the expected outcomes of the 14th UN Congress on Crime Prevention and Criminal Justice in light of the achievement of the 2030 Agenda? The floor is yours, 5 minutes.
Thank you, Tuya. Thank you very much. Welcome, everybody. It's my pleasure to speak on behalf of UNODC and to yet again host this conference together with UNDP, the ILF, OSJI, and a great number of national partners this time. I would like to convey the greetings of the Chief of our Justice Program, Ms. Valérie Lebeau, who could not be here due to medical reasons, and yes, I hope that we will be able to report just as much success as we always do when I meet her again. Indeed, and adding to what all the previous speakers have spoken about today, I would like to underline the importance of achieving the Agenda 2030 through implementing reform on legal aid. And I would like to talk about an upcoming global event which will serve as yet another international forum to share experiences on doing just that. As we have just also heard from the distinguished representative of the Human Rights Committee, it is very important to share experiences among countries, not only how to do the actual implementation, but also to measure success, to reform strategies, to build partnerships within the country and without, to really be able to report something that we can all build the future on in 2030. I would like to talk about the UN Crime Congress, which I'm not sure all of you know about. It only happens every 5 years, but we have had it since the 1950s. So it existed before we had a lot of decision and policy-making bodies that now convene annually in the UN system. This one, just like this conference here, brings together states, NGOs, activists, academics from all over the world, representing various professions and different disciplines. It's a major intergovernmental forum that has in the past influenced national policies, and it has promoted international cooperation on a number of topics by being able to exchange views and experiences, mobilizing public opinion through a very strong program at the side events, and by recommending policy options at national, regional, and international level. The Congress Declaration is later on approved by the Commission on Crime Prevention and Criminal Justice in Vienna, and ultimately by the General Assembly, where the governments commit to taking action on certain topics. And I would like to mention the example of the last Congress declaration in Doha in 2015, which many of you will know about, which was happening 1 year after the first International Legal Aid Conference in Johannesburg. And notably, it contains recommendations on how the rule of law can protect and promote sustainable development, in that they are mutually reinforcing. And for the first time, it mentioned legal aid in the context of justice reform and as a measure to work on prison overcrowding. The government of Qatar provided funding then to implement key aspects of the declaration, and we very much hope that the next Congress will be just as successful. It will be hosted by Japan in Kyoto in 2020, and its main topic, reflecting what we have heard today, is advancing crime prevention, criminal justice, and the rule of law towards the achievement of the 2030 agenda. This is a unique opportunity to contribute to identifying ways and means to achieve the crime prevention and criminal justice related targets, and also to put the contribution of crime prevention and criminal justice institutions, such as legal aid services, at center stage regarding the achievement of the entire 2030 agenda as a whole. This will be convened almost 1 year after the high-level political forum that Isabelle just mentioned, where states for the first time have reported on the achievements, challenges regarding Goal 16. So it will be an important opportunity to maintain that momentum and give governments as well as civil society actors another platform to discuss. Maybe there will be important learnings from the HLPF that can be carried forward to the Crime Congress. Our work together with partners like UNDP and UN Women in implementing the declarations adopted by the previous crime congresses across all the mandate areas of drugs, crime, corruption, and terrorism is making a vital contribution to efforts towards achieving the SDGs. We see Goal 16 as an engine for progress and an enabling tool for the other goals, which Isabelle has already mentioned, such as on gender equality, the reduction of other growing inequalities, and also the promotion of safe cities. Adherence to its human rights inspired values and principles, we think, will result in a drastic reduction of organized crime, violent extremism, and unsafe migration. Between January and April next year, there will be a number of regional preparatory meetings convened in all the world's regions, where member states will come together to think about what they would like to recommend to be a focus of the Congress discussions and ultimately make their way into the declaration. UNODC has ensured that the discussion guide for these meetings includes a strong reference to legal aid as the most important measure. Effective, sustainable, accessible to all without discrimination, and provided at all stages of the criminal justice process. In May, the CCPCJ will decide which recommendations to take forward to New York. I would like to conclude by saying that with the vast experience that we all have here in crime prevention, criminal justice, and prison reform, we stand ready to continue to support all of you, the governments, as well as national and international actors in their efforts to enhance access to legal aid, particularly in the scope of achieving SDG 16. As Tuya already said, on day 2 tomorrow, we will have a breakout session that is moderated by UNDP and UNODC, where we very much hope to welcome a lot of you to really talk about what works, what could work better, and what you would like to do in terms of achieving the SDG 16 targets at the national level. Thank you very much.
Thank you very much, Ms. Holterhoff, and also for your many years of partnership and for being one of the co-organizers of the 3rd International Conference, and thank you. So now we're slightly behind the schedule, but still good. We would like to welcome Honorable Mr. Dunston Lumbo. He is Judge President of the Gauteng Division of the High Court of South Africa. Also, Mr. Mlamba served since 2002 as the chairperson of Legal Aid South Africa, which provides legal aid to those who cannot afford it. And he is also a trustee of the Legal Resources Center. As we know that many of the countries, including also Georgia, drew on the experiences of Legal Aid South Africa in terms of learning the best practices and indeed modeling on the best practices of the Legal Aid South Africa. So, Mr. Mlambo, what are the how do we place legal aid within this 2030 agenda, which is all-encompassing? And how do we link legal aid to successful efforts to reduce human rights abuses, including unlawful and excessive pretrial detention and torture? So please, you have 5 minutes, and very much looking forward to hearing from you. Thank you.
Thank you very much. And let me also acknowledge and congratulate the government of Georgia and the Georgia Legal Aid Services for hosting this conference. Zaza, sitting next to me, was reminding me that I welcomed him to South Africa in 2014, and he's welcoming me to Georgia in 2018. Thank you very much. I also want to pay special tribute to my fellow travelers from the continent of Africa. Since 2014, and since the adoption of the United Nations Principles and Guidelines, I've seen many governments adopt those guidelines and principles and enact legal aid legislation. So what Jennifer was saying, we thought it was a once-off in 2014. It has proven not to be a once-off, but it has proven to be a vehicle which sees a very good development in the rule of law realm in terms of ensuring that more and more legal aid providers, more and more governments adopt legal aid legislation to make sure that this basic human right becomes reality. In answer to the question, and in the 5 minutes I've been given, mine is to simply frame the issue for discussion. I've titled my talk as Access to Legal Aid, a necessary platform for effective access to justice. And I say this because the premise from which I talk is that the rule of law says any dispute must be resolved judicially. In criminal law, an accused person, a person who is in conflict with the law, has a right to a fair trial. We all say that. We all know that. It's all proclaimed. But central to the right to a fair trial is the right to counsel or right to legal representation. However, central to the right to counsel or the right to legal representation is access to legal aid for the vast majority of poor and vulnerable people. You've heard mention of international instruments. I'm not going to name them. Constitutions, legislation, which contain an expression of this truth. Access to legal aid must be the correct and acceptable platform for access to justice for the vast majority of people. As I mentioned, the adoption of the United Nations Principles and Guidelines to legal aid in criminal justice system is the latest and most recent and powerful instrument that proclaims this truth. And this is the document that gave rise to these series of conferences that we have started. We were in Johannesburg, Argentina, we are now here. Why are we here, therefore, today, I ask? And this is how I frame the issues today. Access to legal aid is undeniably the most critical for meaningful access to justice for all the vulnerable and marginalized groups that we have around us. It is, in my view, the necessary platform on which fair trial rights can be achieved. Access to legal aid is universally accepted as a basic human right. It is a key government responsibility. The principles and guidelines say this. It is the only platform guaranteeing access on a mass scale. Because we all know, very few people in society can afford to hire lawyers, but the vast majority cannot. Hence, access to legal aid. Access to legal aid can be implemented in a number of variable models to ensure cost effectiveness. You can use the salaried model, you can use mixed model, you can use a lot of other models. that are aligned to it, that ensure that it's cost effective, that is, you spend less but you achieve more. Cost benefits analysis statements and studies have shown that key government savings can be achieved through access to legal aid. And I have here savings through incarceration costs. Less people are incarcerated because of the intervention of legal aid providers. You save through judicial resources. Less judicial time is required to process cases when access to legal aid is provided properly. And then you have savings in terms of the saving lost opportunities or employment opportunities. We all know that if you are arrested and you are incarcerated, you lose your job. But through the timely intervention of legal aid providers, you make very good savings there. However, what is the truth? And I think these are the issues we need to talk about here today. We all know and we all confirm that fair trial rights are meaningless without access to and availability of counsel and legal aid. That remains a reality amongst us. We all know that the fair trial right without legal empowerment, a justice system is a fantastic dream amounting to nothing if you don't have legal representation. That remains our reality. Most people lack knowledge and skills necessary to adequately enjoy the benefits of the justice system. That remains the reality. Daily, we have many people in our countries, all of us sitting here, who are convicted, unrepresented, because the mass of the need for legal representation is just too high. We have people in countries that still practice the death penalty. Can we vouch sitting here that every single one of those people awaiting their date with a hangman have justly been convicted and sentenced? Can we? I think we need to ask ourselves that question. How many men and women appear daily without legal representation? I've been to countries where judges despair that they've got to try, convict, and sentence people without legal representations. Many people are exposed to less than acceptable legal representation from a quality point of view. Quality has been mentioned here, and it's going to be an issue that we need to talk about. The narrative is that poverty levels continue unabated. Unemployment levels continue to rise. Marginalization and unequal treatment continue to condemn many people. Poverty should not be a barrier to access to justice. We all admit that. Difference, how I look, how you look, should not be decisive how the justice system deals with you. Marginalization should not be the determination of the access to fair trial right. There remain further barriers to access to legal aid. One of them is the continuing reluctance of governments to introduce legal aid legislation. These are things we need to talk about. The continued tension with legal aid professional bodies and lawyers in general towards legal aid providers. Jennifer mentioned this. We have this happening in a number of countries. Where legal aid institutions are established, we still have the prospect of insufficient funding from government. These affect the legal aid services that are provided. We still have the problem of lengthy pre-trial detention periods. These are issues we need to address as legal aid providers. Quality legal aid services remains a big challenge. These are therefore the issues that I think we need to grapple with in this conference. We have encountered and surpassed bigger challenges. We are still here from 2011, from 2014, and we continue. And we've seen many more people come into our fold. So we can't just give up. We need to continue talking and meeting together and collaborating. The quality consensus building conversation that we will have in this conference is a necessary discussion because quality remains one of the topical issues around legal aid service providers. I end by confirming that SDG 16 remains on the horizon, and it is our responsibility as legal aid providers coming here together to make sure that access to justice for all becomes effective and becomes reality. Thank you very much.
Great, thank you. Thank you very much, Judge Lumbo, and many topics that you have mentioned during your speech just now will be elaborated further during the course of these next three days. What you mentioned about right to a fair trial and necessity of having early legal representation is I think, one of the fundamental issues, as well as the overall issue of how legal aid services can be sustained over the course of time. And you mentioned the issue of having, cost-effective measures while providing high-quality services. So now my last speaker, but not the least, is Mr. Zaza Namoradze. He is director of Berlin office of Open Society Justice Initiative. I would like to thank you, Mr. Namoradze, for your personal and professional contribution in arranging this conference in Georgia. Also, thank you also for being one of the early supporters of legal aid systems. So in terms of recent developments of legal aid provision since the second international conference in Buenos Aires, so how do we ensure that these conference outcome documents do reiterate fundamental principles connected to legal aid, but also if you could reflect on the recent political, but also socioeconomic and other challenges that many legal aid centers are faced with today around the world. And you have 5 minutes, and we will close the session. Thank you.
Thank you. Thank you. Legal aid is about ending class justice. It is about everyone who is charged with crime to be treated equally without their financial, not to be dependent on their financial or social circumstances. So legal aid is a fundamental safeguard to ensure that everyone can enjoy fair trial without ability to afford the lawyer. I'm absolutely thrilled that this commitment is bringing us together for the third time, and this time it is in Tbilisi, in Georgia, under the leadership of the Parliament of Georgia and Georgian Legal Aid Service, together with several organizations, including the organization I represent, the Open Society Justice Initiative. It's an absolute pleasure to be here, to see many old faces, old friends, and to see many new faces, very importantly, which confirms that the circle of advocates to promote legal aid globally and nationally is growing every year. I am particularly thrilled to be in Tbilisi at this event, having been someone who has been involved in the past 2 decades in legal aid reforms globally, and including in my own country, as I come from Tbilisi myself. When the steering committee for the conference 2 years ago started to consider different options for hosting the 3rd international conference, we agreed that Europe would be a kind of a right next place for holding this event, after the first one being hosted by colleagues in South Africa and the second one in Buenos Aires in Argentina. And in considering where in Europe would be the right place to host, and then as we consider different criteria, one of which is that it should be a country which demonstrates kind of the global and national leadership in this area, I should confess, I took the initiative to nominate Georgia. And I did so for 2 reasons. One, it, together with South Africa, was the initiator of the process which led to the adoption of the very beautiful document, very important document, which actually frames the theme of this event and, more importantly, the direction of all our work. It also was responsible, actually, to introduce a provision in the Doha Declaration that Annika just talked about. But I thought that, even more importantly, Georgia really deserved to be the place because of demonstrated work, what it has achieved nationally. 15 years ago, there was no legal aid system. There was nothing in this area. And a group of policymakers and activist lawyers and civil society came together to innovate, experiment, and mastermind the process, which led to really very impressive transformations. The legal aid is a very dynamic field. It's never an achieved or accomplished thing to consider. It's been evolving since the reform has started. I think the first major breakthrough was adoption of the model of public defender, full-fledged public defender model. The lawyers from Europe and policymakers from this region would appreciate how difficult it is to make that breakthrough. It's a virtually impossible task, but Georgia did it. And just several years ago, the Parliament of Georgia amended the legislation to really create a fully independent system which is accountable to Parliament. So I hope that you will use this time in Tbilisi to also learn from the experiences that the Georgian legal aid system can share and offer. Every conference ends with a declaration. We have Johannesburg Declaration, we have Buenos Aires Declaration. We will develop one here as well. Those declarations are really important, I would say, the pieces to really help us think together what are the major priorities for collective action and work in the following 2 years. Also, it really helps us to be accountable to ourselves, to look back and see, we committed to something, what happened in the past 2 to 4 years. And if you have had a chance to look at those who have not been familiar with those two declarations, Johannesburg and Buenos Aires one, you can just quickly see how much actually has been achieved from all the points of actions that we are proposed, that put forward by those declarations. Let me take just the few moments here to talk about two really critical developments in this regard in the past 2 years. It was said that the number of countries have, or the number of countries which have adopted new legal aid legislation has grown. Kenya is one of the latest examples of really progressive legislation, just to name few. And just a few days ago, I think it was mentioned by Jennifer that Kenya hosted East Africa Forum to create a sub-regional network of legal aid providers. These are really very important efforts to really help and inspire and support each other regionally and sub-regionally and globally. But coming back to Europe, what happened in Europe? There are very serious problems in Europe. Legal aid is, when it comes to legal aid, in every component of legal aid. So 2 years ago, the European Union adopted a legislation, a directive, as it is called, which becomes the law of 25 EU member states. It is entering into force next year, so the transposition will end actually next year, and then the countries in Europe are required to ensure that legal aid is provided promptly, but no later than before the first police questioning. There are systems in place which guarantee independent appointment of legal and timely appointment of legal aid lawyers. There are requirements of quality that should meet that guarantee the equality of arms and fair trial, and there are remedies that should be established in case this right is violated. So there is a real hope that this legislation will really push significant reforms in Europe. It took 3 years to negotiate the EU directive on legal aid. There was really fighting for every word. Eventually, I think the instrument we are left with is a really good one. It's not ideal. We wanted more, but it's still enough to really give impetus to significant reforms. But as we all know, the real work starts after the passing the legislation. So it really will depend on all of us, just really to really give meaning to the many important provisions that this legislation is putting forward. And just to also briefly mention one significant international development, if we, the data is critical for, to understand whether what we do is doing any good, how do we know if we are making any progress. So it's both nationally and internationally. And internationally in this regard, there was really a very important development at the UNODC. There is an annual survey tool of crime statistics, which for the first time, it was amended last year and now includes the data and indicator which will measure access to legal aid during police custody. So I think it's just kind of really making some initial steps in building more data, more knowledge about how governments are essentially performing or delivering legal aid. Now, in terms of our outcome document, which we are going to draft, and the great, the element of this process is that it's actually all of you will be drafting it. So those of you who are interested to participate in this process, we will start the meeting in a working group during the lunch break. We will have lunch during that break in the meeting in a separate room, room number 3. The draft outcome document is prepared for your review, for everybody's review. As soon as you leave this room during a coffee break, please take a copy with you. And those of you who would like to participate in this drafting process, please join us in room number 3. Maybe to mention 2 elements that I would like to really call upon you with regard to the upcoming work. One, Annika kind of indicated about the occasion of the Crime Congress in 2020 in Japan, which is a real opportunity to push things further. And our declaration is one of the good places to articulate what it is that we want the Crime Congress to do and what it is that we want to do to ensure that this will be achieved in Japan at that place. But the second, next year, it's the first moment, first occasion when the UN will review how the implementation of SDGs has been progressing. So they will look at 4-year period. It was adopted in 2015, so in 2019 they are reviewing progress of implementation of several goals, which includes goal 16, under which all governments committed that by 2030 there will be equal access to justice for all. Obviously, this is very critical and formidable commitment, which requires a lot of work, and we need to look at what it has been achieved. Now, next year in July, as a first step in this process, high-level political forum will review governments' reports. These are voluntary reports that governments submit. And it is up to governments what they want to report on, because there are many targets, as you know, and many indicators. So I would like to ask all of you, so there are 51 countries which volunteer to report during high-level political forum next year. And people who can make sure that access to justice and legal aid is included in the report are here. So all of you, when you go back to your countries, if you could make efforts to work with your governments, and many of you also represented those governments, to have legal aid be part of that, it will raise real profile of this topic, will raise awareness of the high-level political forum, and will make critical contribution in assessing the progress of implementation, and even more importantly, will identify what needs to be done in the next 4-year period in order to make a greater progress. Thank you very much.
Thank you very much, Mr. Namoradze. Also, thank you for helping choose this beautiful country and beautiful city as the location of the 3rd International Conference. And I'm sure participants will have a chance to enjoy the very famous hospitality of the Georgian people. Also, one point that you mentioned was that the outcome documents, they do not just stay on paper, and that is very reassuring to hear, that in fact these are our collective priorities for every 2 years, as long as this mechanism can be sustained. So very much looking forward to collectively working with all of you towards the 3rd outcome document, Tbilisi Declaration. And indeed, thank you also for highlighting some, of course, very key challenges, starting with Europe and other countries, but also some key progress made, especially in terms of commitments through legislative acts. You mentioned Kenya as a great example, but also as the support and commitment of the EU to provide legal aid services to its 25 member states. I would like to express my sincere gratitude to my distinguished panelists. Thank you so much. You have highlighted very different aspects, and I would say that you laid the foundation or fertile ground for further discussions and further breakaway sessions. And I would like to wish all of our representatives seated here very interesting deliberations, but also opportunity to network with each other in the coming 3 days. Thank you very much, and now the next session will start.